This is Human Rights Frameworks for Asian American and Pacific Islander Advocacy. We're thrilled that everyone could be with us today. This is one of the first programs that we're having as part of a new project at the Asian Law Caucus, the Korematsu Institute. The Korematsu Institute was established to further the legacy of Fred Korematsu and his leadership on civil rights issues in this country for all communities of color. And as core to the Institute's work is knowledge creation activities that allow activists to take a step back and really think about what are our strategies for impact, and are we really moving the needle in terms of a broader set of goals that we're trying to achieve for racial equality. And so we're really excited to have this panel today. It's hard to think of a more illustrious panel to really help us grapple with this question of, can we use human rights frameworks effectively in the context of API advocacy? So, as some of you may know, the system of international human rights standards was constructed over a long period of time, beginning with the Universal Declaration on Human Rights in 1948. And initially, there was strong US leadership on the issue. Eleanor Roosevelt was on the drafting committee of the Universal Declaration. But then we went through a very long and very dark period when in the US, we really did not apply the international human rights standards to the work in our own countries. We talked about human rights as something that needed to happen over there in Guatemala or in China, but we didn't talk about how we needed to hold ourselves accountable to those same standards that we were trying to promote overseas. A lot of this happened because of the Cold War context and because of particular challenges that an earlier generation of activists, including folks like Martin Luther King, encountered when they tried to use human rights frameworks and were then labeled communists, were labeled traitors, labeled people who are un-American. And has to do with kind of a prevailing culture that has existed in the US around US exceptionalism, which unfortunately is still very much with us today. But something did shift post 9/11, in part because the challenges were so great post 9/11. And we saw the ways in which the current civil rights infrastructure that we have in this country was not really adequate to meeting those challenges. And we were also confronted with a very hostile domestic judiciary, which made it very difficult to advance our goals in terms of civil rights protections, using the more traditional frameworks and tools that were at our disposal. And so since 9/11, this really interesting shift has started to happen where social justice organizers, activists, organizations, working on a range of issues, have begun to use human rights frameworks along a number of different dimensions, from organizing to litigation to policy advocacy. But we really haven't had a lot of very deep conversations yet within the API community about how does this play out for the type of work that we're doing. There's an issue around the particular issue areas we work in, but maybe in a more profound way it has to do with what are the opportunities and challenges when we are organizing and advocating in largely immigrant communities. And so on the one hand, there may be some opportunities in terms of connecting with immigrants that have a robust experience from their home countries of actually deploying human rights frameworks, which can be more common across a number of countries in Asia than the civil rights framework, which is really very American. But on the other hand, it may pose some unique challenges as well, particularly for immigrants coming from a post-communist context. Because our community is so diverse, it's going to play out in many different and complex ways. But what we're hoping today is to begin having that conversation about how it plays out, and then to strategize around what we can do next to really think about how to be most effective in reaching our social justice goals and how the human rights framework may fit into all of that. So I'm very excited to turn now to our illustrious group of panelists. We're going to start with Krishanti Damaraj. She is the founder of the founding executive director of the Women's Institute for Leadership Development for Human Rights. And she has, she worked on a path-breaking campaign in San Francisco, which resulted in the first municipality in the US to adopt a human rights treaty. So she's going to talk about that, but she's going to start with a little bit of background about what we're seeing more generally in terms of this relatively new move of bringing human rights home. Thank you.
Thank you very much. Good afternoon. I want you to imagine a ledge where people are falling from, right? Either because they're being pushed or because that's where they are, right? And when people are falling from a ledge, what you normally see, right? That this is the work we are doing, right? You see people holding nets to make sure they don't fall through, right? So that there are safety nets, right? Then you see people counting the number of people falling, right? And then there are others making sure, trying to figure out who's pushing them, right? Sometimes we blame the people who are falling for not looking at where they're going, and sometimes we believe that they're being pushed, right? And so the focus has been usually in our work around from the point of people being on a ledge to falling and who's being harmed. Right? But think about what it would mean for people not to get to the ledge in the first place. Using a human rights framework really is about making sure people don't get to that ledge. So you have, I think, in all our work, we have seen, when we think about the world and world of human rights, pretty much 30% of human rights. That is about counting the bodies, the sensationalizing of who's falling, who's holding the net, and who's pushing. That literally is about 30%. But most of the work that goes on around human rights, the comprehensive approach around our inherent dignity, regardless of who we are, right, is about making sure people don't get to that ledge, right? And so the basic definition of human rights is about constructing conditions in society for people to be fully human. It's very basic, right? Constructing conditions in society for people to be fully human. Which means from our end, as communities who are struggling for justice, we have to define what it means to be fully human. Right? And this is the most extraordinary power that human rights allows us. We have to define what it means to be fully human, no one else. Of course, because we are human, there are some basic conditions we're talking about. So when you think about working on issues, right, such as poverty, right, such as healthcare for undocumented immigrants, we have sort of an approach of begging, right? We are asking and pleading so that we will get something, because somehow we are not worth that. But imagine if you are robbed, how you would react. That right is yours because you're human, no matter who, regardless of where you were born, and somebody else is affecting that right. And therein lies the difference in the human rights strategy in empowering communities to speak up and demand for their rights that were once theirs to begin with, not that we are asking. Right? So basically in human rights, we are talking about something called respect, protect, and fulfill. Respect means that the government, right, should not directly violate your basic human right. Right? The government, and then you hold governments accountable. This is where most of the work is, right? There are reports written, and we say that the government has violated this set of rights. But the other two are as equally important, right? What it means to protect a right is that there's always a third party involved, right? And especially in the United States, when you think about it, the government says, no, it's privatized, right? It's a private act. We have nothing to do with it, including if you think about domestic violence, right? So the government is, the government is not battering someone. However, the government is obligated to make sure that if a woman is beaten in her home, that there are the necessary protections, right? And it applies for corporations as well, right? So it's about the protection that the government is obligated to make sure that it has, right? The third one is around fulfilling. That means, rights are evolving. We keep redefining it. It's not stagnant and static, right? And we have seen that about, we talked about women's rights being human rights only in 1993, right? So that ideal for people to claim their humanity, to be fully human, right? The government has to make sure that they put the necessary steps in place, right? So this is about fulfilling. If you think about, I think for us about discrimination, that's what we talk about. Human rights gives us one of the most comprehensive definitions of discrimination, right? It talks about distinction, exclusion, and restriction, or preference based on race, color, caste, creed, right? And it talks about all the spheres, civil, political, economic, social, cultural, right? And for example, when we talk about the discrimination against women, it also talks about public and private, right? So in the United States, human rights has been spoken about and worked on, especially with the African American community and the indigenous community. However, post-Cold War, it's a brand new kind of movement. And this particular way of doing human rights in the United States actually began in the 1990s, and very specifically, the organizations that started doing human rights work in the United States were all started by women of color, right? So the organizations looked upon, they were in the East Coast as well as the West Coast, looked at litigation, right? Education and scholarship, right? Policy, advocacy, organizing, and documentation. I think now I am supposed to briefly talk about what happened in San Francisco, right? Is that?
Yeah,
okay.
yeah, if you could.
So this is kind of the range in which human rights work is continued in the United States, and I think the panelists will talk to that, right? In San Francisco, when you think about proactively doing work, and I think in our discussion session we would talk more about the pros and cons of it, we were dealing with post 187, Prop 187, and Proposition 209. So the aim was to really look at how do you have set of principles and guidelines in San Francisco. We will test run it because everyone was asking, what's the purpose of human rights, right? So our aim was to really show that it does make a difference beyond the existing civil rights strategies. So we took something called CEDAW, Convention on the Elimination of All Forms of Discrimination Against Women. It's a mouthful. Human rights world always makes up very long names for basic things. And it is about really looking at ending discrimination. And we got this passed as policy in San Francisco with a multi-issue cross-constituency organizing strategy. And it was proactive, which allowed and demanded that the city government looked at, provide a gender analysis in employment, service delivery, and resource allocation. Okay? And extraordinary successes have taken place since then. One of the first things that took place, and I will end here, is the first woman to, San Francisco actually has more women appointed to city positions than any other city, I think, in the country. However, they are not in income-generating, powerful places. So because of the human rights analysis we were able to do, the first woman was appointed to the Airport Commission, and an Asian woman, Carol Eaton, right? And I want to end by saying human rights to me is not a choice, but it's a necessity, whether it is for me and for my life and what I bring as well for my children. And this is about our inherent right to dignity as a community. Thank you.
Thank you. So we're going to get down to nuts and bolts a little bit more and hear two different perspectives from two very different organizations on how they're using human rights frameworks in the particular programs of their organization. So first we're going to hear from Jamil Dakwar. He's the director of the Human Rights Program at the National ACLU. And as many of you know, the ACLU has really been extremely innovative in doing some very path-breaking work on incorporating human rights frameworks into their core mission of protecting civil liberties. Thank you.
Thank you. Well, thanks for inviting me and being part of this crowd. As a Palestinian, I think I consider myself as Asian, but for some reason, when you come to this country, they ask you to label yourself. You have to be Asian American, and then people tell me, no, you're not Asian. And I said, but this is what I learned in geography class when I was a kid. And we are in Asia, and we're Asians, and yet this is not how the people think about it this way. So, so there's now, of course, after 9/11, Middle Eastern and South Asian Muslim Arab community. So it's a mouthful and long, but I'm happy to be here as Asian, and so I first really think that this is a really great opportunity where we connect, coming from different organizations and perspectives, and working on a number of issues. I think it's great to have this conversation. I was also heartened to see, the no human being is illegal on the cover, and seeing human rights is also very much infiltrating into the substance of this great, gathering and conference. And the same thing what we're trying to do at the ACLU. The American Civil Liberties Union, as many of you know, is one of the largest civil liberties organizations in the country, founded in 1920, with mostly focusing on civil liberties like First Amendment, state and church, very boring stuff. But I'm telling you, these are important things to fight, and I think we had, as an organization, established a record of protecting civil liberties and move to other areas that affect people in this country. And that 50, 60 years ago would not be perceived as civil liberties issues. For example, immigrants' rights, women's rights, racial justice. These are all programs within the ACLU. But in 2004, the ACLU created the Human Rights Program. It hired me and two other colleagues with human rights background to establish and found the Human Rights Program, with the aim of making the ACLU as a largest domestic civil liberties organization, is also using the human rights tools and strategies, and hopefully become more and more of a human rights organization with the component of the knowledge and a commitment to international human rights. And that's different from the way that the ACLU has been dealing with a lot of domestic challenges. So I wanted here to briefly talk to you about some of the work that we've been doing over the past 5 years. In fact, just next month we will be turning 5 years as a program. We were hoping to celebrate this and kind of try to think about what are the next 5 or 10 years for us, and as an organization, as a program. How do we work with communities and our sister organizations and colleagues in establishing not only a strong ACLU human rights mandate, but also building the US-based human rights movement. That's been really, and since I came to this country, I feel like this is ridiculous that people in tech human rights, it seems like if you're talking about some kind of an alien, foreign thing that has nothing to do with this country or has nothing to do with reality on the ground. And indeed, it was people like Martin Luther King who said, in his words, what is necessary to say now that we're moving now from the civil rights era to the human rights era. And that's what Martin Luther King. And there are others who, Malcolm X, who also said similar words. and other people who we're not inventing the wheel, in other words, but we're trying to create a reality where we can use the human rights framework in a very innovative and strategic way. So we at the ACLU, since we are a legal organization, we do a lot of litigation. One of the things that we try to do is to find ways to incorporate human rights arguments into some of the leading cases that we've been working on since 9/11. Be it national security cases, trafficking cases, women's rights cases. Sometimes we lost remedy in domestic level. We taken our cases to the international fora. We're taking them before the Inter-American Commission of Human Rights. We've taken them to the international level, to the United Nations human rights mechanisms. The other things that we did fact-finding or documentation of abuses and violations, using the human rights analysis and methodologies, using the principles and norms that are acceptable worldwide but have not been applied in the United States. And we produce reports, both shadow reports that are counter reports to the United States government reports under human rights treaties that were ratified, as well as reports that were, for the first time, documenting abuses. And that's, I think, here the powerful tool of human rights, is that you are using the voices and providing a megaphone to the victims of human rights violations to to tell their story, and to tell their story in a way that was not acceptable before, where you have to choose. Are you going to tell the story as a woman, or as an undocumented woman, or as a gay person, or as a person with disability, or you want to tell it as you have to choose where you stand. How do you want to raise your voice? But here with human rights, I think it offers a much better way of demanding justice, and at the same time coming up with a framework that is complementary. We're not going to abandon the US Constitution or the Bill of Rights. We are going to add to them more protection. We are going to expand people's understanding how human rights can make people's lives better. I am short of time, but I wanted to give you a couple of examples of two successful stories of how we dealt with that. And I don't know if you want me to stop here and say that in the next round.
No, go ahead. Go ahead.
Yeah, to do that?
Yeah.
Okay. So quickly, one was using as I said, the advocacy when the litigation did not work. We represented, for example, women, Latina woman who was a victim of domestic violence. She lost her case all the way to the Supreme Court, where she demanded a remedy for the fact that the police was not able to protect her from her abusive husband, and ended up in a tragedy of killing the two kids and himself. She tried to demand that the police knew about this abusive husband, who was supposed to protect her and take affirmative measures to enforce the protective order, and yet the police did not do that. When she went to court, the court did not accept this theory, saying that the police could not do that according to the letter of the law. She took her case, and we helped her take her case before the Inter-American Commission of Human Rights. This is a commission that is within the Organization of American States. The United States is part of this important organization. It has a number of Latin American, Central American, North American countries. And this commission heard her story, Jessica Gonzalez's story, for the first time. She was able to testify and with the lawyers to make arguments that why the United States have failed to protect her and many other women in the United States. We are now in the moment where we're waiting for a decision to come down from the Inter-American Commission. Now, this decision might not be enforceable in the United States because it's not legally binding to take a commission, but the US government did engage. They did present their defense. They provided people from the state of Colorado where the incident took place. And now we are taking that decision and bringing it back to the US and say, the United States has the moral obligation, if not the legal obligation, to enforce this decision, to make a remedy, effective remedy to women like Jessica Gonzalez. So this is just one quick story of how you take an issue that has lost in the domestic arena because you don't have a broad human rights protections, and take it to the international level with the human rights analysis and arguments, and trying to establish some sort of a broader effective remedies. The other case was how do we did with racial profiling. Racial profiling on the border with the El Paso community. And we're sorry we don't have with us our brother and a great advocate, Fernando, who could have spoken about their struggle on the US-Mexico border, a daily struggle. And what we did as an ACLU is to join forces with Fernando and the local groups in El Paso when we advocated before the Human Rights Committee that was reviewing the United States compliance with the International Covenant on Civil Political Rights. We brought the case of a sheriff in El Paso who was abusing his power and was stopping Latino, and 80% of people who were living in El Paso were Latino, on racial profiling, basically, all kinds of pretexts, and was harassing, intimidating people. And that was really an issue that the federal government was not similar to, not in the same level of breaches like Sheriff Arpaio, but was a smaller case of some of the violations. We were able, when using the human rights advocacy before the Human Rights Committee, to let the Human Rights Committee question the United States government on the case of racial profiling in El Paso. Have had headlines in the newspapers, both in El Paso and others, that the sheriff of El Paso was taken to the United Nations for violating the human rights of the communities. And then once the committee concluded, they had specific language addressing and condemning the US for failing to protect communities from racial profiling. And that was used by advocates in Texas, in the Senate, reading the recommendations and using it as a way to end racial profiling. The sheriff ended, after all this pressure and other things that the local groups were doing, ended up suspending this program of racial profiling. So this is just in a nutshell. I'm sorry, I'm rushing. I'm not giving you all the, the drama and all the things that happened. But this is just to give you an example of how you can certainly use human rights mechanisms and arguments and in the benefit of people who you're working for their rights. Thank you.
Thank you. That was terrific. And there'll be another opportunity. So next we're going to hear from Macy Chen. She's the director and co-founder of Community Asset Development Redefining Education, CADR. CADR is an organization that does grassroots organizing right here in Los Angeles on educational equity issues.
I have to admit, I thought I was going last. So, no, that's okay, but it's my fault. And I just want to, again, express my appreciation for being part of this very, very important convening. And as TT said, I am a founding director of an organizing group called Cadre in South Los Angeles. And we organize parents specifically and only around educational issues, very specifically in South Los Angeles, and very intentionally across both African American and Latino communities. And, but when I say that that's what we do, often a lot of different things surface, and a lot of assumptions surface about what our aims are, what our goals are, what we must be training the parents to do. A lot of, I'll just be very blunt, a lot of very condescending and purely racist versions of what we must be doing to improve schools down in South Central LA. So I'm going to give you a narrative. I'm going to ask you, and sorry we don't have time to actually take some examples of your thoughts, but I'm going to give you a situation and I'm going to give you 3 different narratives, ways to look at it, and ultimately I will emphasize the human rights one, of course. So a parent has a child suspended from school multiple times in a year and who has a history of conflict with teachers. Okay, so the personal responsibility narrative, the floor would be, that parent must not know how to raise her child. The ceiling might be, she needs parenting classes. And I'm not a civil rights lawyer, but I will say the next narrative, if it's a civil rights narrative, I'll ask many of you to think for yourselves what the floor might be in civil rights. Well, is there a law that, well, there is no law, because there is no law, unless that child is designated as special education. But there is no law that would automatically find that situation to be a violation of any rights. Primarily because obviously discrimination must be proven at such a high level. The burden is so high that those situations can't even be articulated and aren't even taken seriously. So there almost is no floor in that case. And it's ironic that in civil rights it's somewhat, it's actually a weak floor and a very low bar ceiling. And the ceiling might be, well, if we can find other people like her, so many that we can do a class action lawsuit, it might not even be worth dealing with. We just need to advocate for her individually. But then 2 days later or down the street, it's happening again and again and again and again to thousands of children all across this country. So from the human rights narrative, the floor is different. And I'm going to feed off of what Krishanti said. The floor is completely different. The floor is saying that child is a human being, first and foremost, not a student, not a client of services, not a child of some bad parent, not a student that's somehow a target of a public institution, but a human being. And and then the ceiling becomes something completely different. The ceiling becomes, okay, how do we actually critique the conditions in the school, in the community, in that child's surroundings that might have led that child to have conflict in the school, to not feel connected to the school, to not want to go with the program, so to speak, and be an individual dealing with trauma possibly, dealing with substance abuse possibly, dealing with many, many things that for whom being in a low-income community may not have any support to address. And then the ceiling becomes a full remedy. A ceiling becomes talking about that child's life in general, that child's future, that child's potential. Because in human rights, education is supposed to fulfill a child's full potential. Not to go to college and get a good job and earn some money, but to fulfill their potential as a human being that they can live and thrive in their life. So that's just an example. So we obviously do the latter, and we do organize parents for that situation. We both support individual and collective advocacy. We have used, a lot of people will say to me, well, what does human rights really add to an organizing model? But in the end, it really is about redefining the floor and redefining the ceiling. And in so doing, you train differently, you educate, a much broader, more holistic, comprehensive level. And who you target and what you target them for is different. So is it just to get them back in the school, just to get a letter of apology, just to make sure it doesn't happen again? No, those are things sometimes we have to ask for in the meantime, but really the ceiling is about how do we make sure this child's dignity and right to an education is not continually violated from here on out? What systemic policies have to be put in place? What practices have to be monitored and evaluated in the scope of a child's educational experience? So I will go into it further if we have time, and I believe there will be a roundtable after if you all have more questions. But I want to give you an example of how we apply the human rights framework in our education organizing and how it just really creates a different narrative with a different agenda at the end of the day. And I hope it was, I was hoping to say a lot more, but I hope that was informative.
Both Maisie and Jamil were great about staying on time. So I was wondering if I could actually ask you both one follow-up question, which was, why did your organizations decide to adopt the human rights framework? And I don't know as much about Cadre, so it might have been built in from the very beginning, but if so, why? And with ACLU, it's been a relatively new kind of coming to Jesus moment, so how did that come about?
So in terms of how the organization, there are two things that I think that happened that made it happen. That the ACLU now has commitment and institutional commitment, and also better understanding in using human rights and doing that, and joining many other groups. Is first we have an executive director who came from the human rights world. He was at the Ford Foundation. In charge of grants given to human rights and justice work around the world, and came to the ACLU and said, one of the things that I want to do and change is to get the ACLU up to speed on using human rights. And I think that commitment had helped the organization do the right thing. But I think the more important thing is really the 9/11 consequences. And these are what I think you alluded to that in your opening. So if we think about something positive out of this horrible, tragic, 9/11 attacks, is that you have the people in the United States, not only people who are thinking progressively, but thinking of what went wrong and what is happening out in the world. And I think it compelled a lot of advocates that were not used to hear the Geneva Conventions, for example, after rounding up the detainees and opening Guantanamo, where for the first time the Bush administration said, oh, we are not going to apply international law, Geneva Conventions. They don't deserve human treatment under Geneva Conventions. So people started to go back to their, as far as lawyers, go back to their textbooks, like, what's Geneva Conventions are? What is that? What is that animal, So, and then there are other people who are like, with the rounding up of undocumented persons, and there are 700 or 800 people who were rounded up just in the city of New York, stripped of their rights, and they were held secretly with no notification of their families. I mean, horrific things that happened, and we still don't have the accurate record of what happened since 9/11. So people started to think about concepts and tools and ways to address those violations using human rights, both legally and I think more in the messaging, in what it means to be fair, what it means to be dignity, human dignity, how the government can deal with national security threats, but at the same time preserve civil liberties and human rights. So I think those things have made the organization look. There's no way this country sooner or later will have to join the international community in realizing that this is something that's happening, and international law and human rights in particular is something that is going to be part and parcel of this country. But it's going to take time. The country moved dramatically to the right, as we've seen in the Supreme Court, and we've seen in communities, in policymakers and elected officials. But the bottom line is, I think that was the ideal of how to use the human rights in responding to the backlash and in responding to the deterioration and setbacks in protection of civil liberties. All of a sudden, people realizing, as lawyers, maybe that's more kind of speaks to the ACLU, courts are not doing enough to protect people's rights. So you have sometimes get more results from having a strong human rights report than litigating a case over 10 years. Or a human rights report will help you as an advocate, as a lawyer, to get a remedy for your clients. And so that has how this evolved. And we're saying, I think it's evolving, and the only thing that I'm still struggling with is how to make it a comprehensive approach, including social economic rights. The ACLU is still a civil rights, political rights, civil liberties heavy organization. We do work on education, we do work on other economic justice issues, but they are not fully based on the understanding of social economic rights that are interdependent with, as part of the whole framework of human rights. And that's, I think, the challenge of not only the ACLU, but as a country. And the healthcare reform debate is about that. People are not still, getting the idea that, well, you can't, it's not between socialist regime and like a capitalism. There's something has to be in the middle where people's dignity and rights are being respected, and the government take responsibility of preserving and fulfilling those rights.
Yeah, that's actually one of the most powerful things about the international human rights frameworks is that they consider rights holistically,
Right.
and there are strong protections for economic and social rights, which do not exist in the U.S. Constitution.
And on that same note, you all have heard me speak about education. Education is a human right, but it also falls within the realm of economic and social and cultural rights that are part of this kind of missing piece to the full human rights agenda here in the United States. And quickly, just to say how we came to it, it was not initially part of Kadri's theory of change, but in organizing, as maybe you know, you work with the folks who are obviously who have the most to lose or gain by your successes or your failures. So I will say that we did this collaboratively with our core parent leaders, and there were some key decisions made between 2004 and 2005 that really shaped our work. One, and we debated and discussed it and decided together that we would be about systemic social change. It wasn't just to get more people through, get a bigger piece of the pie, like so much of the education reform agenda is now, including in the Obama administration. It's very much not progressive, unfortunately, but it's more about getting a bigger slice of the pie. But systemic social change, because the underlying structural racism in schools was still there. It doesn't matter if you get more people, more pieces of the pie, that the racist premises of the schooling system are still there. So it was about systemic social change. Our parents wanted to work on education specifically to fight racism. Two, okay, what's the system we want to change? The quote-unquote system, what does that mean? And in our case, we specifically named it as the school-to-prison pipeline that is really the de facto system in most low-income communities of color, specifically African-American and Latino. That you have greater chances of being poor, jobless, and incarcerated or detained and arrested and always having a record than you do of going to not just college, but having a meaningful economic and social and cultural life. And then, well, what causes the school-to-prison pipeline? That would be a set of conditions, policies, and practices that all converge to push out more kids than the system keeps. So while many people call it dropout, we obviously call it push out because we think it's really the aggregation of many, many things that leads to a situation where it's a lot easier to leave than to stay. And then we also made the decision in 2005 to adopt the human rights framework. And primarily it's because it resonates with our parents. It speaks to all the issues that Jamil was talking about combined in a human experience, because people don't define it like as issues and cases like some of us may. Obviously people live it, and you can't separate one from the other or one from the 5 other issues that we may look at, but they all combine. And human rights is probably the most profound framework in terms of just acknowledging the humanity of when all those barriers and violations compound in one human experience. And secondly, our parents were just shocked that there was no guarantee to a right to education. And nothing in our law or constitution guarantees a quality education, let alone an education. So that really was our rationale. And I just want to say quickly that organizing and using human rights in an organizing framework and using it in education and using it to attack the real structural racism that still exists in our school, that's very evident through the school-to-prison pipeline, is really something that we've been doing for several years now, and you are all going to hear more and more about it in the coming years as it starts to get on the map, so to speak. But I do want to say that part of it is also redefining the purpose of education, standards in education, and who benefits from education. And I think for those of us who are Asian Pacific American, Asian Pacific Islander, Asian American, Asian, we really have an obligation. I think it's almost mandatory at this point that we actually look at our commitment to education in this country, not through our experiences, but through a human rights lens. Because really, at the end of the day, the structural racism is dividing us from other communities of color. We're not connecting with the human rights violations in our schools today, and we're not necessarily working at bringing enough to bear on the structural racism that still exists, that unfortunately we have benefited from. The same violations that some groups experience are flipped around, and we benefit from it. From having a purely racial view about who cares about education and therefore who is worth educating. And as a reason, I just want to leave that with all of you to consider as we continue this conversation.
Yes.
Before I started Wild for Human Rights, actually it was started by 3 Asian women, one Chinese American from Hawaii, and the other immigrant to the US from Indonesia, and then myself. And it actually got started, we kind of shook hands on it to start Wild for Human Rights on the Great Wall when we were there in Beijing in 1995. The reason for that were threefold. One was that I was working at that time at Amnesty International, and in the evenings I would volunteer at Asian women's shelter in San Francisco. Two very different worlds, but I was working on women's human rights. The conditions that women were facing were the same, and I couldn't understand why you couldn't use it, in San Francisco. Later on, then it also happened that we were not just talking about Asian women, we were talking about immigrant and undocumented women, right? And then I would go to look at refugee cases for Amnesty International, and we're talking some of the same things, and using human rights, and making enormous successes in challenging, the immigration, attorneys in saying, like, you're talking about, gender-based violence, right? So it was then really thinking about how do you then bring up to speed looking at undocumented and documented, women and US-born people, right? And women in this continuum, especially looking at women of color. And so there was actually in 1993, there was the first hearing in the US was held in San Francisco called Human Rights Violations Against Refugee and Immigrant Women in the US. And it was organized by predominantly women of color before women's rights or human rights, were kind of proclaimed in 1993 in Vienna. So, and the third was, I felt very schizophrenic because in one sense I had to talk about race, in another case I had to talk about gender. So part of the experiences of really starting Wild for Human Rights to address rights of women, right, was based on those experiences of a group of us, and to see, can we look at it holistically? Can we be positive rather than negative? Because when we are negative, we kind of know what we are working against, like violence against women, right? And it's very limiting. But do we know what we are for? I think, and human rights allowed us to be and talk about what we were for, and therefore really build the leadership of women around.
Thank you. So one of the resources that we really have within this community as we start to think about this work is that many of us come from countries where there has been incredible and very sophisticated work done around using human rights frameworks for advocacy across a number of different issue areas. But that's not really a resource that many of us have accessed in the past and that we've really thought about and connected with. And so today we have with us Rangita De Silva, and she is the Director of International Human Rights Policy for Wellesley Centers for Women. And she's worked very closely, particularly with women's rights activists throughout Asia, on connecting the work that's going on at a very grassroots level around gender equality to CEDAW and the international mechanisms. And so she's going to talk a little bit about some examples of how, in the home countries of many of the people that we work with, there have been these successful examples. And for us, it has a particular dimension because it means that there may be ways to really value the experiences that immigrants bring into this country, instead of only thinking about, how do we ensure that immigrants coming in understand this new framework to them, around civil rights or U.S. civic engagement. It's really about how can we respect the experiences that people are bringing in, really value them, and really deploy them.
Thank you. So my discussion is actually a passage to Asia, then to the United States. And I hope that this tour de force will provide you with some critical insights into the novel ways in which human rights advocates and lawyers in Asia are using the human rights norms and the framework of human rights in very transformative ways, and in fact stretching the potential of the human rights norms and frameworks. Their work is indeed a testimony to the vibrancy and the dynamism of human rights norms and how it can be reinvented to be used in a way, in ways that are unexpected, given unexpected situations. And when I look at the ways in which human rights norms have been used in myriad ways to actually stretch the potential of women's human rights and to push the boundaries of women's human rights advocacy in Asia, what I see is that the human rights framework has been used as a very powerful tool to galvanize and mobilize disparate women's rights groups and movements. And the human rights norms and the frameworks are often the glue that holds these communities together and binds them together and brings them together on a universal language and a common vernacular. So that, for me, is one of the most powerful, powerful effects of the human rights framework. Secondly, the human rights framework is often used as a litmus test or a benchmark in envisioning and re-envisioning new laws and revisions to existing laws. And secondly, these frameworks are used as powerful interpretive tools to enlarge existing laws and to fill in the gaps when domestic laws are either absent, non-existent, or weak. So these are what I would call the three pillars on which the human rights advocacy in Asia have been built upon. And the final pillar is one of the most important pillars that most of you have been alluding to, the fact that human rights frameworks are often the most important tool to hold states parties accountable to either violations of human rights or inaction on their part to fulfill the obligations that are enshrined in the human rights framework. My passage to Asia starts in China, and I would be remiss if I don't very quickly refer to the fact that Titi herself has left an enduring legacy in China, but that is another story, another narrative that I will talk about later. Yes. So going back to China, as you might be very well aware, human rights norms are not self-executing in China, and they cannot be invoked in court or in judicial decision-making, nor can they be read in directly into lawmaking. But
right,
lawyers and women's
there's
rights
Chinese
advocates,
exceptionalism and there's U.S. exceptionalism.
women's rights lawyers and women's rights advocates have been using the Convention on the Elimination of Discrimination Against Women, which is one of the most powerful, a very important progeny coming out of the UDHR, the Universal Declaration of Human Rights. And they have been using the CEDAW, or the Women's International Bill of Rights, as the foundational norms for their drafting of experts' drafts on domestic violence and anti-discrimination. And this has been extremely inspiring because what you can see is a direct transformation or a translation of these international human rights norms into domestic documents. And sometimes you see almost a cut and paste job when it comes to defining what is domestic violence. Domestic violence is defined in very specific ways as it is translated in the CEDAW and in the Declaration on the Elimination of Violence Against Women. So when you read the experts' drafts on domestic violence or on anti-discrimination, what you see is an invocation of the Universal Declaration of Human Rights and the CEDAW. And that has been one of the most unique ways in which the translation of international human rights norms have been taking place in Asia. Going to Vietnam, what you see is actually a direct reference to the CEDAW in their latest law, which was recently enacted, the Gender Equality Law. The preamble itself embraces the CEDAW and enshrines it. And what that results in is that the CEDAW then becomes almost like a supremacy clause that could help resolve conflicts that might take place later in the interpretation of the laws. Similarly, in the Philippines, what you see that in all of the laws affecting women and children, whether it's a law on trafficking, sexual harassment, children's rights law, the Magna Carta for women, or the domestic violence law, all of the international human rights documents that the Philippines has ratified have been enshrined in the preamble of these laws, thereby making these international human rights norms supreme in those laws. Now, going very quickly to India, traveling to India, what you see is that the panoramic sweep of India's creative use of human rights norms has inspired not just Indian advocacy groups, but groups around South Asia, whether it be Nepal, Bangladesh, Sri Lanka, or Pakistan. And what you see is that, once again, the CEDAW, the CRC, the Convention on the Rights of Child, and the ICSCR have been used in very unique and novel ways to enlarge the interpretation of the domestic laws, or to fill in the gaps when there is no domestic law to address a cause of action. For example, in a high watermark case, Visakha versus Rajasthan, where a woman was severely sexually harassed, there is no sexual harassment in law in India for these advocates and lawyers to rely upon. And the human rights lawyers therefore used the CEDAW to enlarge the interpretation of the Equal Protection Clause, and said in order for the Equal Protection Clause to be used as a live document, as a live breathing document, it has to be read and enlarged in the spirit of the CEDAW. And that is exactly what the US Supreme Court, the Indian Supreme Court did, and it argued that that the CEDAW must be read into these provisions to enlarge the meaning and the content of the Indian Constitution. Similarly, in a panoramic sweep of cases, what we see is that the CEDAW has been used to dismantle child marriage, to dismantle unequal inheritance laws that disallowed women from inheriting equally with their brothers, dismantling unequal guardianship laws, which disallowed women from having custody of their children until the death or the separation of the father. And most importantly for your own work, using the UDHR in very creative ways to provide the same protection to a non-citizen that would be available to a citizen. So in this case, the court held that a Bangladeshi woman who was not a citizen of India would have the same rights to the protection in a case that violated her right to life, and that she would be entitled to the same constitutional guarantees that were enshrined in the Indian Constitution that were available to an Indian citizen. And the Supreme Court invoked the UDHR to state that the UDHR provides protection without any distinction as to race, color, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status. Therefore, there is no reason why the UDHR should not govern in India and would not be held supreme in the case of protecting the rights of a non-citizen in India. Going very, very quick to Nepal, I find that the Nepalese women's rights movement has been using the CEDAW, the CRC, and the UDHR in very poignant and powerful ways. For example, enlarging the definition of rape to cover marital rape. And in fact, in a very interesting judgment, the Supreme Court of Nepal, using the CEDAW, stated, it cannot be said that any man who commits the heinous and inhuman crime of rape to a woman may be immune from the criminal law simply because he is her husband. And therefore, it broadened the definition of rape to cover marital rape. And the Supreme Court stated the only reason why this woman would not get the protection of the criminal law is because she did the heinous harm of getting married. That was the only reason why she would not have the same protection. Again, in Nepal, what the women's movement has done is use the CEDAW as the benchmark, as the litmus test, to review the whole landscape of laws affecting women to see whether those laws complied with the spirit of the CEDAW. And in doing that, what they found were lots of gaps in the civil laws. For example, in one provision of the civil law, the Muluku Ain, there was a provision which allowed a husband whose wife had been disabled during the marriage to get a second wife. But this was not allowed for a wife. A wife could not have the privilege of getting married again or have taking a second husband if her husband was deemed disabled during the marriage. So although this is again referencing the need for a holistic application of the human rights norms, although Nepal is yet to ratify the Convention on the Rights of Persons with Disabilities, which would have helped them strike down this violation, they used the CEDAW. They said this is against gender, this violates a woman's rights. And also made, in their application to the Supreme Court, made an appeal for the Supreme Court to ask for a directive for the state to ratify the CRPD because of the ways in which there was this facially discriminatory provision in the law itself. So this was, again, a very vivid example of a need for a holistic application, a holistic understanding of the ways in which the intersectionalities of human rights work. Finally, to go to Pakistan, because I know that my time is up and you may be having questions, the CEDAW was used to strike down provisions in the laws that allowed women or disallowed women from marrying without the consent of their guardians. So in a case, in a very high watermark case, Noor Hatin, the case of Humaira Kaka, where this woman had got married without the consent of her father, the police were complicit with the father and arrested her and beat her and her husband in custody. So this is a case of custodial violence too. In this case, again, the lawyers, the women's rights lawyers who went before the Supreme Court had to use the CEDAW because the law actually disallowed her from getting married without the consent of the guardian. So you see how the conventions really provide the powerful tools to address human rights violations when the law in the domestic region is silent on those laws or in fact are complicit with the human rights violations. And the Supreme Court did, the Pakistani Supreme Court did quote the CEDAW in saying that that she has the right to, she has the freedom to marry, and that the CEDAW provides for the freedom for marriage. Again, around Asia, what you see is that the CEDAW has been such a powerful tool in dismantling unequal retirement provisions, where, for example, in the case of the Noor Hatina case in Indonesia, when women were asked to retire at the age of 40, while men could carry on working till the age of 65, and in the case of the Sudoku case in Japan, where women were asked to retire at the time of marriage. In both cases, this gets funnier. I mean, in India, women who were flight attendants and civil servants, foreign civil servants, are asked to retire at the time of marriage on the basis that they have onerous duties to perform at the point of motherhood. And the Supreme Court Justice in India actually stated, well, those same onerous duties apply to men too, as fathers and husbands, and therefore, it's completely unconscionable that these human rights norms do not apply equally to both men and women. And it was so funny because the Supreme Court Justice Krishna Iyer said, I have no doubt that that there are onerous duties that are upon both men and women. And he was not in any way diminishing the need for parental responsibilities or duties. Again, I'm rushing, but I want to show you this sweep of the ways in which human rights norms have been used in such constructive, strategic, powerful ways to dismantle human rights violations in Asia. And I think this is really a call to action, a clarion call to bring that home here to the United States. Thank you.
Thank you, Rangita. Rangita is a database of information of that type. I was just at a conference with her recently, and we were making fun of her because she was citing examples from Iceland, and then the next example would be from South Africa. So if you want examples like that, get in touch with Rangita. She has many, many of them. And a couple of other resources to look at. There was a report that the Ford Foundation commissioned in 03, 04, somewhere around there, entitled Close to Home, and it has a fabulous set of examples of organizations here in the US that are using human rights frameworks in very powerful ways. Wild for Human Rights isn't that, right? Well, for Human Rights is in that, is one of the case studies. Another case study is the Border Network for Human Rights, and Fernando Garcia, the executive director, was supposed to be with us today, but he's been very ill, and he works right on the US-Mexico border, so there were some very serious concerns about H1N1, and so he was not able to be with us today. But there is a case study of his organization in that report. And there's also a terrific report that just came out by the Rights Working Group, which Karen Narasaki had referenced earlier today at lunch, and the ACLU, looking at racial profiling in the US, but framing the whole report around the Convention on Elimination of Racial Discrimination, CERT. And so it's a great example of how you can use the international human rights framework to document the abuses going on in the US around racial profiling. So those are two resources people can turn to. And now we're going to shift gears a little bit. None of our panelists, except for myself, work exclusively or even primarily with API communities. But we did establish earlier on the panel that we are all Asians. So given that that's our baseline, I was wondering if each of you could speak just for a couple of minutes on what you think the challenges in particular, because we've already talked a lot about opportunities, what the challenges might be in particular of implementing human rights frameworks in API social justice advocacy. You can talk a little bit about the opportunities as well, but just for a couple of minutes, because I wanted to then open it up so that we can have more questions and a dialogue. Macy, would you like to start?
I would answer that question using probably the three narratives that I spoke about when during my previous comments, and really that I think the narrative of personal responsibility is often something that we all struggle with, not just in our community, but in this country, period, and certainly worldwide. And it's one thing to believe in it and one thing to act on it. It's another thing to absolve the government of responsibility, however, when the conditions and protections and fulfillment of human rights do not exist structurally and systemically. So I think what's difficult is, and in my personal work around education, that it's a challenge here in the United States, period. People whose rights are being extremely violated day in and day out will still opt for a personal responsibility argument, even around their own situation. And it can be quite, unfortunately, very vicious sometimes when talking about other groups or other people. And so I think that's our challenge. But again, I provided three narratives of the personal responsibility, civil rights, and human rights. And ironically, I think it's easier to move from personal responsibility to human rights than it is from civil rights to human rights. Again, I'm not an attorney, but I will say that sometimes, as much as our attorneys are the biggest champions of human rights, they are sometimes also our obstacles in believing that there are no legal handles, and what good is that? And it sometimes translates to organizers who don't feel there are any handles, quote unquote, in human rights, anything to hold on to that binds people. But I truly believe that human rights is both a structural tool, but it's also a moral and mobilizing tool where people are responding to their, as Krishanti said earlier, our own belief in our dignity, as well as our humanity and our right to be human and operate as human beings when we run into challenges in our livelihood. So I think, again, the personal responsibility argument is huge, but I actually believe that the narrative can move quickly from that to human rights if we actually apply and do a very good job of talking about what human rights really are.
Macy said earlier that we, as the APA community, have really benefited from some of the structural discrimination that has taken place against other ethnic and racial minorities. So I think it's important in that sense. I mean, so civil rights, you know, that we have used, that we know about, it's the known animal, right? And when you're shifting from civil rights to human rights, it becomes very messy. It's not very direct. It's not a clean-cut way of doing things, right? We know civil rights. There are cases that we can cite, right? There's a yes-no. We know we have to prove discrimination, right? Whereas the challenge of using human rights is that it is an intersection of identity. It's not just one part of you. You have to bring your whole self and the whole self of the community, right? So you can't tell the community, and we can't tell, like, can you hold on to all of that other stuff? We'll just deal with one of those things, which we are used to doing, right? So it becomes more complex when it's holistic. And then that, the next challenge when you're holistic is that it takes time. So it is not about saying, okay, here's the right we are going to work on, and this is how we are going to work at it. Because if you go back to the definition I talked about, constructing conditions in society for people to be fully human, therefore people must define what it means to be fully human. It's a slower process. And in a world of funding and quick results, right, and benchmarks and impact, it's much harder to show that. And the third is this is, I think, a challenge for those of us who are doing human rights work within the US, as well as outside. There's a distinction between using human rights as a strategy and using human rights as a framework. I think those of us here are using it as a framework as well as a strategy from time to time. But it came out that it is a framework that we are using. And in a quick fix world, initially folks begin by using it as a strategy, and later on we can talk more of it, and that is an obstacle.
I want to agree first with Shanti about the whole move from civil rights to human rights. I think that is certainly a challenge. I mean, you hear it from African American communities, even Latino communities, even though there's more fluency among a lot of immigrant communities, certainly Latino and Asian communities, that they come from countries where you have much better human rights infrastructure, if you want to use that term, where it's really embedded in the daily struggles of people, of movements, workers' rights, and women's rights, and children's rights, and so forth. And here it's totally different. You come into, okay, you have to go into the melting pot of the American society, and the melting pot is you have to take the path of civil rights. And there's nothing wrong with that, except that over the years, we know that there was a rollback on a lot of what you can achieve using civil rights and sometimes even constitutional rights framework. And you ought to think outside the box. And this is when people historically started to refer to human rights. Let's shine international spotlight. Let's try to sometimes, yes, compare what's happening in the United States with the rest of the world. I mean, the fact that the United States is the only country, and Somalia, that have not ratified the Convention on the Rights of the Child is outrageous.
And it's because we wanted to be able to execute juveniles.
Right.
Right.
Now, this excuse is not available because the Supreme Court, fortunately, addressed this problem of executing juveniles. But yet, that is still not even considered by the Obama administration, not to mention Congress. And I wanted to use some of the time that I have to tell you about the Campaign for New Domestic Human Rights Agenda. That is an emerging campaign with over 50 US-based social justice, civil rights, human rights, and civil liberties organizations have come together shortly after the last election, the presidential elections, and rallies around 4 major goals that were identified by Professor Catherine Powell, who commissioned a report for the American Constitution Society called Human Rights Blueprint for the United States for the next administration. And she had advisors from a number of organizations, including 3 former US Undersecretary of State for Human Rights, Democracy, and Labor, including Harold Koh, who, as many of you know, is now the legal advisor at the State Department and one of the prominent figures in the administration supporting human rights, and former Yale dean. This campaign is trying to identify 4 areas and said, let's work let's be realistic. First, we don't have the mechanisms to enforce and monitor and review human rights violations in the country. There is no national federal human rights commission, as many countries do have. There are civil rights commissions and some human rights commissions in some states, but they don't really follow the human rights framework. And that's really interesting how they use the word human rights, but yet when you look at what they're doing, they're really enforcing Title VII, like employment discrimination and other types of discrimination. So one of the goals was, let's reform and strengthen the existing US Commission on Civil Rights that was created in the 1950s to enforce civil rights laws, and adding a human rights mandate. So this commission, which is a very important commission, but yet over the years has been discredited and lost really credibility and became more partisan, let's give it a human rights mandate, following some of the examples and practices in other countries. So there's the Leadership Conference for Civil Rights, that is a composition of over 250 organizations, including two major, I looked at the list to make sure that I'm not wrong, the Asian American Justice Center and the Japanese American Citizen League, sitting on the steering committee of the Leadership Conference for Civil Rights, now demanding that the US Civil Rights Commission incorporate human rights mandate. This is, I think, revolutionary. This is an important step. So I encourage everyone to look at this campaign and this particular demand and the US and the creating Human Rights Commission. The second one is to reconstitute the Interagency Working Group on Human Rights. This is an interagency within the Obama administration, and we've been calling for establishing this interagency working group so people will understand who is enforcing human rights treaties, how the administration is dealing with new human rights treaties that have not been ratified, how the enforcement and implementation is carried on. Nothing of that is known to anyone. So now, hopefully, the administration, and we're really working hard to get this done by Human Rights Day on December 10th, when the Obama president will be receiving the Nobel Peace Prize in Norway. We heard some kind of discouragement. Oh, well, you know, we don't want to make the president say something about human rights when he receives the Nobel Peace Prize, because that would be, very apologetic, to the world. So we're still very hopeful that that will happen. The third and the fourth goals, quickly, working with local and state human rights commissions and civil rights commission to help them incorporate human rights framework. And that's, some models are really particularly interesting there. And the fourth goal is enforcing international human rights treaties that were ratified by the US, particularly the third. It was mentioned, the Convention on the Elimination of All Forms of Racial Discrimination, a treaty that the US ratified in '94, much more needed to really incorporate this treaty into our laws. Just yesterday, the president signed the Hate Crimes Prevention Act, which is actually bringing the US in more compliance with the international human rights obligations. So hopefully that will be something that will energize and not only national groups that are based in DC, but also grassroots organizations. If your community is interested, and we are offering models for local ordinances and some language on how you can pass resolutions on Human Rights Day, and it starts with inspirational statements and resolutions, but then it goes into more legally binding, more spreading the culture of human rights.
Thank you. Thank you, Dan.
Very quickly, I do not work in the United States. My work is all international. But one problem that I perceive as might being a problem here in the US, and I'm actually sure it is a problem, is something that is universal. As you know, and as we all mentioned here today, that human rights are indivisible, inextricably interrelated, that there's no hierarchy among rights. However, women's rights do come into conflict, as we saw in the example in Pakistan, with the right to religion. And that often becomes a challenge here in the United States too, when rights collide, when rights clash. And that is really a challenge that I want to pose to all of you, because you're the ones here as foot soldiers, working in the front lines of that. And I have a different take on how we address this in Asia. And when we talked about the CRC, you also see that CRC is a Bill of Rights for Children, and parental authority can come into some kind of conflict with the rights rights of the child, and that is really, pervasive here too among the Asian American community and the kind of cultural context and baggage that they bring here. So that is really, a polemic that I want to throw there, and rather than provide you with my insights, I like to hear your insights on that.
Yeah, so we're ready at this point to open it up for questions and comments. We are a little bit short on time, but I think we can do 5 minutes of questions and comments. Chris.
Do you think that there is a way that civil rights and human rights can peacefully coexist in the U.S. context? Because I'm thinking of what Eva Patterson mentioned at lunch, that we do need to be visionary but also pragmatic. And where the U.S. Population is that they understand human rights. In fact, people in power, the majority groups who suppress the rights of minorities, claim civil rights violations against them. And people really understand what civil rights are in this country. I think the human rights framework that you've laid out is very compelling, but it seems to be in a double bind in that it's not fully accepted by the American population and it's not recognized in the courts. At least the civil rights, people understand what it is, and while we are not winning all the battles in the courts, we still have some victories there that we use as handles. So I understand what you're proposing, but is there a way that we can have these two movements be in unity at some point?
Right. If I may, just quickly, I think I absolutely think that this is, that's what I think I agreed that this is going to be the main challenge. I think that the filling the gaps, or when there are no answers to problems where the civil rights framework is not providing enough remedies or answers, where you can look at the human rights framework and say, here's how it works under the human rights analysis. Here's how some countries developed models that are workable, are providing answers to hard questions and problems. And I'll give you 2 examples. One is the whole concept of alternatives to detention. This is not something that is completely obscure from the American public. People understand what that means. Or issues of the right to rehabilitation, reintegration into society, giving a second chance. These are concepts that people relate to, and they are very much in the human rights framework, but they are not fully accepted, enforced in the civil rights model. And that's why, for example, a lot of immigrants, undocumented immigrants, are being kept behind bars, where alternatives to detention are not even considered. That's why a lot of juveniles, a lot of minors, children under the age of 18, have been locked behind bars with not a possibility of reintegration into society by seeing detention as a first resort rather than a last resort. So the alternative to detention is a concept that has been grown in the human rights framework and been supported by a lot of societies that are seeing the value in providing second chance and not immediately think about resolving a problem that could be resolved in the principal's room rather than sending the kid to a police station. And that's kind of things that you can bring up in a practical manner, in a real life situations, and incorporate them. You don't have to use them human rights if they are resisting the words human rights. And we give this advice to some of our members, across the nation. People come from Kansas, say, are you kidding me? You're going to say human rights, I'll be thrown out of the door. You can't use those words. Certainly not in Congress sometimes. I go down to Congress and say, you have to be diplomatic and how to frame this and how to talk about this. The other quick example I want to give you is about affirmative action. We got into really a deadlock with affirmative action on the civil rights framework. Yet the affirmative action called special measures under international human rights law is widely internationally recognized. Even the United States government called on new democracies like Iraq and Afghanistan to use affirmative action. Yet when it comes to the United States, no, affirmative action is it's not acceptable. This is, and you know what? That's how you have to do, constantly keep that interaction between the two frameworks. I'm not saying that they will, there's no coalition and there's no confrontation, but no, let's see how can we incorporate the human rights framework into existing frameworks, because at the end of the day, human rights law, international law, relies on domestic effective enforcements. Without that, we can't start. So we have to start with civil rights, what we have, or we have to expand that.
Just,
Yes.
I'd like to add to that. I think we have to, civil rights and human rights are not two separate things, right? So human rights actually includes civil rights, political rights, economic, social, and cultural rights. So all these 5 things. What we have done in the United States is lift up the civil rights component of human rights. Okay? So, and in every sense of the word, all of those other things have been there and will continue to be there. So lifting up, right, has required has given a spotlight and also dealt with its own limitations. So I think it's very important to realize that these are not two separate things, right?
Yeah,
and it's incorporated.
That's very important.
And let's talk about Proposition 209, and I'll give you an example, right? So Proposition 209 passed in California, and we were on a deadlock. And temporary special measures is the language used, right? And the rest of the world, especially after CEDAW, Convention on the Elimination of All Forms of Racial Discrimination Against Women, has been ratified, people have used it in multiple ways. So in San Francisco, when we started the campaign to pass CEDAW in San Francisco, the question was Proposition 209. It had just gotten passed. So here's what we did. We first said human rights is not about quotas. It is not, right? And the city of San Francisco, after passing CEDAW, part of its obligation was to do a gender analysis in the allocations of funds, service delivery, and employment across the city in 64 departments. So all we were trying to do is to look at what is the gap around men and women when the city engaged in positioning money, right? Programming and resource and employment. And I'll give you one example of that, okay? Women, the city said women don't apply for non-traditional jobs. Department of Public Works does not have enough women. It's not because we don't want women. They just don't like us that much, right? So a couple of questions from the human rights analysis that we did looked at what time does daycare start? 8 a.m. What time does work start for Department of Public Works? 6 a.m. Okay, therein lies the gap, right? So after that, now there are more women in Department of Public Works. They have actually a coalition and a lunchtime brown bag session that they go on to talk about sexual harassment, and the department has improved. The program aspect of this particular department, again, we were told it's not gendered, it's about humans, right? However, street lights are based on men's level of comfort. There's no law about where the street lights ought to go in a city, right? When majority of the people who work for the Department of Public Works are men, they put street lights based on their level of comfort. However, we know, although women face violence in the home most of the time by people they know, we have a different fear when it comes to darkness. After the gender analysis was done based on human rights, right? Now the street lights in San Francisco are much closer. Okay? That is how human rights works, very proactively. And that we could not have got from civil rights. So I think the aim is not to figure out whether it's civil rights and human rights and the tensions, but to look at holistically how to address it.